Hello, everyone. It is Rob Ryder on Wednesday, November 30th, 2016. My last video, just a couple days ago, actually, 2 days ago, was on case dismissed administratively, in which I showed that over the last couple of years, in a couple of court cases where I'd gotten around to actually submitting things to the chief judge, which is basically just a private letter to the chief judge of the county or that court system for that area. Now, these were state courts. That the cases got dismissed. Now, it wasn't clean dismissal, and you couldn't say it was from the letter. I'm just saying, letters are submitted and the cases were dismissed. And so, is there any possible way of building on that? But hang on just a second, please. Okay, so also in that video, I had pointed out that I had found this thing called the military sworn statement form. This is kind of what it looks like, sworn statement form for use with AR 190-45. And then I had this thought that, well, instead of just sending a private letter, I would use this sworn statement form because it has a really nice, here at the bottom, an affidavit that you would sign before who's ever going to be your, like a notary, right? Subscribed and sworn before me, a person authorized by law to administer oaths. And then witnesses. Now, I don't believe you need to have the witnesses there. They're just really going to be witnessing the same thing that you said in the affidavit that an official witness has signed for you. So that's a little level farther than I know, but I would just say, okay, well, I can take it down to the notary, have them do their thing, and then go find two friends to be witnesses to complete the form. We don't all have to be in the room at the same time, I guess is my point. I don't know that to be true. I'm just guessing, right? So, anyways, so today we're going to look at that, and then instead of sending it just to the chief judge, well, option B might be to send it to the Central Violation Bureau, which is the federal clearinghouse for petty crimes, misdemeanors, and felonies. Or we're going to try to make it that way. Although there is a place called the Central Violation Bureau. Here it is, Central Violation Bureau. It's part of the U.S. courts. So this is www.cvb, Central Violation Bureau, cvb.uscourts.gov. And, what I noticed as I was going through here is, hey, they got an email address. They got a fax, someplace to fax. Okay, well, we should check into this a little bit deeper. And that was the plan. So, but before we can do that, I have to ask, hey, can you please donate? It is the 30th of November, and I can't pay my rent, which is due on the 1st of December. If you can, and you have PayPal, well, then the easy way to do it is just use PayPal and send it to my daughter's PayPal account name, which is her email address, right? You have to go to PayPal, and that's her PayPal account is her email address, ashleyrytlewski@gmail.com. ASHLEYRYTLEWSKI@gmail.com. If you had a credit card, well, I have another PayPal account that I believe I can use with a credit card, but I have to send you an invoice. And so you'd have to go to courtofrecord@AOL.com. I've never done it, but I do have it, and, we can see if it works. Or there's always the mail. Just mail to Robert Rytlewski at 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. And so please donate. So let's go where? Where first? I guess what we're going to do is look at this filled in sworn statement. Anyway, so I had done the video, and as usual, you do a video and then the phone rings a few times and you get emails and all sorts of things, and some lady had a son that was in some trouble. And so I said, okay, well, that's simple enough. Let me write this up. So let me read it first, and then we'll go through it. Now, of course, this isn't quite completed. We need to have a location, a date, time, file number, we don't put the file number. I don't believe it comes from somebody else. Put your last name, first name, middle name. Because it's not in parentheses, I would do it just the way it says. If you see name and then in parentheses, last name, first name, or middle initial or something like that, I wouldn't. Myself, I don't do that anymore. I cross it out and I just put my name the way it is. Robert Allen Rytlewski. That is my full legal name. Your social security number, your grade or status, right? You can be a civilian. You can be an elector. You may be in the military. You could be a veteran. Just whatever your status is. And your address. And then and here you would put your full legal name, want to make the following statement under oath. And so this is kind of my idea. To whom it may concern, and the Central Violation Bureau, United States Courts, and presiding judge of Superior Courts of California, County of St. Louis Obispo, 1050 Monterey Street, St. Louis Obispo, California. Army Regulation 840-10 makes clear that only those in military service may fly the national color. That'd be in Chapter 1-7, Restrictions, Unauthorized Use of Official Flags, Guidons, and Streamers. It goes on to say that the national color flies in military courtrooms. That'd be in Chapter 2-3, Sizes and Occasions for Display. In case they didn't know, I have included Sections 1.7 and 2.3 of this regulation as an exhibit. I wish to inform the presiding judge and the Central Violation Bureau, United States Courts, that the attorneys at law, under the presiding judge's supervision, are engaged in a simulated legal process to extort private wealth for their personal gain from the peaceful inhabitants of this land in violation of both the Lieber Code martial law and the Constitution of the United States. In military courtrooms, flying the national color that the presiding judge has a duty to enforce his superintending control over. In other words, hey, buddy, downstairs people are breaking the law, and it's your duty to do something about it. Officers of the court involved in case number, there's actually 3 different case numbers. This is what they do. There is never just one case number for your case. They have multiple case numbers. Sometimes they use extra zeros. Sometimes they put 2016 instead of just 16. Anything, right? If they're different, and they're different for a reason. So, this one has at least 3. Wantonly violate Article 6 and 11 of the Lieber Code, as well as Article 6 and the 14th Amendment of the Constitution of the United States, in your courtrooms flying national colors. Take judicial notice. California Government Code Section 100 states, the style of process shall be the people of the state of California, and all prosecutions shall be conducted in their name and by their authority. This style is not used in the mentioned cases. Instead, these simulated legal processes substitute the pseudonym people of the state of California, contrary to law. So in other words, in the California Government Code, Section 100, it states the style of all processes shall be the people of the state of California, with the being part of the proper name. And that isn't what is on these documents as being the plaintiff. And so they're not using the style of that's supposed to be used for all processes and prosecutions in California. And so it's not the state of California that's prosecuting. So who are these people, and what is it that they're trying to to prosecute with if they're not using the state laws? They're just making it up as they go along. And on these forms, then, here's a place to put exhibits. You're supposed to initial how many pages. You just have to read the whole thing. And then you have an extra page if you want to write more. You could write as much as you want for your statement, but eventually you get to the last page, and my idea is not to have these any longer than necessary. So, take judicial notice. No court seal is in use. The lack of the use of court seals evidences that habeas corpus and the Constitution have been suspended and the country is under martial law. They never use court seal on their documents. Just look at an order issued by a judge and see if it's got a court seal. Doesn't. That means you haven't been to court. Well, that would mean, hey, habeas corpus is suspended. They're, not taking you to court. They're just pretending it's court. Here's a list of but a few of the other legalities being disregarded by your subordinates. The full legal name of the court is concealed. No court seals of a court of record being used. Alleged officers of the court use pseudonyms instead of their full legal name. Alleged legal instruments they submit have omissions and simulate a legal process. Multiple case numbers are being used for the same alleged wrong. The full legal name of Daniel Joe X's is being concealed from official records, and instead the pseudonym X's, Daniel Joe, Jr. represent the defendant. No properly cited state or federal law is claimed to have been violated. These abuses of power constitute military oppression, and I demand the presiding judge or U.S. magistrate protect the peaceful inhabitants from subordinate officers' abuses, return their ill-gotten gain, clear the good name of Daniel Joe X's, Jr., and ensure such belligerence ceases in all courtrooms under the presiding judge's control, or I have no choice but to inform a higher military authority of any refusal to do so. Well, that was my idea. Hey, this is what's happening in your courts. You can do something about it yourself, or I'm going to have to go take it to somebody else in the military. And at the time, as I was doing this, I said, well, I'm just going to write it to the chief judge. But then I had come across this thing about the Central Violation Bureau. I said, well, yeah, I'll send it to them also. And then here's the affidavit part. So my idea was, well, okay, you would fill this out, and this particular lady, in her case, she's supposed to be in court tomorrow. Her son is on Thursday. I said, well, go take it with you, put it in the court, and give the chief judge a copy of it. And hey, now and then when we're done, we'll email a copy to this entity here, this Central Violation Bureau. So let's see how that goes. Now, I did want to point out something. Here's the regulation on flags. So all this I covered in much more detail in my last video, but just to show that this is where it comes from. Army Regulation 840-10. In which it says, in Chapter 1, unauthorized use of official flags, guidons, and streamers, there is no law that permits the sale, loan, or donation of flags, guidons, or streamers to individuals or organizations not in the military service, except as indicated in 1 or 2. Display or use of flags, guidons, streamers, or replicas thereof, including those presently or formerly carried by U.S. Army units, by other than the office, individual, organizations for which it is authorized, is prohibited except as indicated in 3. So first of all, if you're a school, you can have a flag. If you're a retired general, you can have a flag. And then if you meet 3, you can have a flag. Well, I don't believe that's most county buildings. They don't meet those criteria. They have the flag, and all these courtrooms have the flag. And the President of the United States, he gets the national flag, which is the flag without the fringe on it, whereas the national color is the national flag, and it does have a fringe, and that's the flag that the Army has. So when you see in the President of the United States' office a flag with the fringe, that's him as the Commander-in-Chief. If it doesn't have fringe, that's him as the President of the United States. See, national color. All these different Army units have a national color. And then it says, this is, what section is this here? Jeepers. I think it's 2.3. Yeah, section 2.3, sizes and occasions for display. And if we go down here, national flags listed below are for indoor display and for use in ceremonies and parades. For these purposes, the flag of the United States will be of rayon banner cloth of heavyweight nylon, trimmed on three sides with gold, yellow fringe, 2½ inches wide. It will be the same size or larger than other flags displayed or carried at the same time. The 3-foot hoist by 4-foot fly, this size flag, will be displayed with the Army field flag, distinguishing flags, organization colors, and institutional flags of the same size. It will also be displayed within the offices listed in C below when no other positional or organizational flags are authorized. Authorization of indoor display. The flag of the United States is authorized for display for each, and here we go, 4 military courtrooms. So I'm going to say, hey, if there's a gold fringe flag in a courtroom, it has to be a military courtroom because only the military is allowed to have the frickin' flag. You have to be in military service. It's unauthorized to use official flags, guidons, or streamers. There is no law that permits the sale, loan, or donation of flags, guidons, or streamers to individuals or organizations not in military service, except as indicated in 1 and 2. Educational institutions and retired general officers. Well, that pretty much takes out the county court building. Alrighty, and we can close that one. And hang on just a second. Let me regroup a bit. Okay. So on the sworn statement, it said at the top, for use of this form, CAR, yes, 190. 190-45. Okay, now I can close that. Now let's take a look at that. Army Regulation 190-45, Military Police Law Enforcement Reporting. If you Google Army Regulation 190-45, you will find a way to get to a PDF and you can download your own copy. And because this is a little bit hard for me to read the way that they're written, I've taken out the parts that I'm interested in for the time being. I haven't studied this completely, so if you know an MP, they'd know this much better than I do, provost marshal, something like that. I'm only interested in a few parts to see if I can use it, and well, this is what it says. So in the Army Regulation 190-45, Military Police Law Enforcement Reporting, it talks in 7-7 about the Central Violation Bureau Form. U.S. District Court Violation Notice. They look like something like this, which looks like a lot like a uniform ticket that they would have in every state, except this one is federal. So it's like a uniform citation. The CVB form is an accountable form prepared by law enforcement personnel to report minor offenses to include violations of state traffic laws applicable to military reservations. This form is used only in conjunction with magistrate court system. With a magistrate court system. That will be important before this is over. Yada, yada, yada. I'm not going to read all of it, of course. Installation PMs, that would be the Provost Marshal, or DES, that would be the emergency something or other. How about Director of Emergency Services? That's who it is. Must maintain liaison with their local U.S. magistrate to determine accountability of the form and the referral of charges. The U.S. magistrate inputs data from the CVB form into the CVB. So from the form into the Central Violation Board. That's what the U.S. magistrate does. He's an input, whoever this magistrate is, he's just inputting data. He's taking the form and putting it into the system. And so what they do is they take this ticket. I'll just quickly explain it the way I see it. They take this ticket and they send it down to actually someplace in Texas where it gets processed and then goes to the local federal court for that area, who's then going to call somebody to court. Excuse me. Provost Marshal, Director of Emergency Services, the senior officer, military, civilian, directly responsible for law enforcement and security, regardless of the individual's position or title. The individual must occupy a position that involves the administration of criminal justice. So that'd be a good person to find if you're close to a military base. Because they're talking about any place that is under federal control that, that this can be done. Well, that would be a post office. Right? They're flying a flag. Well, they're under military control. So, to me, all this shit applies. Initiating Provost Marshal, Director of Emergency Services. The Provost Marshal, DES, who first records a complaint, initiates police actions, and subsequently initiates an MPR on a criminal offense or incident. Investigation, jurisdiction with responsibility to investigate criminal offenses based on geographical boundaries or the category of the offense. Unfounded offense, a criminal complaint, in which it's determined is made the criminal offense was not committed or did not occur. This determination is based on police investigation and not on court-martial findings, civil court verdicts, or command determinations. So what that means to me is, well, if I submit a complaint, they have to investigate it. They may decide that there was no criminal offense committed, but they at least have to investigate. And that's when I said, well, I'm going to use this. I'm going to see if I can send my complaint to the Central Violation Board. 710, DA Form 2823, that's the sworn statement form, right? It is used to record written statements of all persons related to whatever an MPR is. And then the Central Violation Bureau, the administrative office. Now, again, this is out of the Army's procedure, right? So in there, they're talking about the Central Violations Bureau. The administrative office of U.S. courts established the CVB for processing violation notices. Each U.S. district court has local court rule or order that provides or authorizes a preset forfeiture or of collateral amount for persons charged with certain petty offenses. Rules for processing misdemeanors and other petty offenses are proclamated under Rule 58 of the Federal Rules of Criminal Procedure and by the individual courts. The existence of local rules does not prevent law enforcement personnel from requesting the filing of a complaint against a defendant in lieu of issuing a violation notice. These procedures merely provide an alternate method for handling petty offense cases, a method which is usually more convenient for the law enforcement personnel, the defendant, and the court. But again, it says the existence of these local court rules does not prevent law enforcement personnel from requesting the filing of a complaint. Well, I'm not going to wait for them to request it. I'll just file it with them to the CVB. And my complaint will be on a sworn statement. Even though the amount paid is stated in the fine is actually a posting of collateral, which is forfeited if the defendant pays and does not request an appearance before U.S. magistrate judge. Again, that's if they use the form. Right, that's if somebody's charging you with something. I'm trying to figure out how to use this to charge somebody else. Acceptance of payment by the CVB terminates the proceeding. Local, federal rules and state law determine whether moving violation were reported. There are certain offenses when forfeiture collateral is not permitted. These offenses require mandatory appearance before a U.S. magistrate judge. Also, a defendant will request a hearing before a U.S. magistrate judge rather than paying the forfeiture collateral, and a hearing will be scheduled. So if you don't want to pay it, you say, well, I want to have a hearing. Well, they would do that too. The CVB or the U.S. magistrate judge will process these matters. The U.S. attorney is responsible for all prosecutions in the U.S. District Court and the coordinating of law enforcement efforts. Generally, the U.S. attorney delegates to individual agencies authority to issue violation notices and to prosecute petty offenses initiated by violation notice. As an example, Judge Advocate Generals have generally been authorized by U.S. attorney to prosecute certain crimes in which the Army has an interest. These are commonly referred to as Special Assistant United States Attorneys. Chapter 11, Use of the Central Violation Bureau Form. The basis of initiating action by U.S. magistrate system is the CVB form. The form is designated to provide legal notice of violation. Okay. Statement of probable cause. And the promise to appear will be used in compliance with installation staff, judge advocate, and U.S. magistrate or U.S. district court policies and instructions. The statement of probable cause printed on the back of the original CVB form and is required to support the issuance of a summons or an arrest warrant. And so they're talking about this on the back. So if they just want to get you for a petty offense, that there's no arrest, there's no jail time, it's just a fine, they'd use the front. If it's a little bit more serious, like a misdemeanor or whatever it ends up being, well, they would use the back. And what are they doing? They're going to, I declare in the penalty of perjury that the information which I set forth on the face of this violation notice is true and correct to the best of my knowledge. Okay. Well, that's what the back is. Well, that's the same thing as you doing a sworn statement. It's just a statement of probable cause. The statement of probable cause and the promise to appear will be issued in compliance with installation staff, judge advocate. The statement of probable cause printed on the back of the original CVB form is required to support the issuance of a summons or an arrest warrant. The promise to appear, printed with instructions to the violator on the inner flap of the envelope, is optional, and some U.S. magistrate, U.S. courts will elect not to use it. Use of statement of probable cause. In compliance with guidelines issued by Administrative Office of the U.S. Courts, the reverse side of the violation notice provides a statement of probable cause. This is required by Rule 58D3 of the Federal Rules of Criminal Procedure to support the issuance of a summons or an arrest warrant. The statement of probable cause will be printed on the reverse side of the original violation notice on all copies of the violation notice or as a separate form. So it doesn't need to be on the violation notice. And the probable cause statement is what is used to get an arrest warrant or a summons. Upon receipt of the probable cause statement by the issuing officer and finding a sufficient probable cause by U.S. magistrate judge, bench warrants forwarded by the CVB to the U.S. magistrate judge will then be signed, dated, and issued. If the statement of probable cause has been properly completed by law enforcement personnel, the U.S. magistrate judge can then issue the bench warrant. And so if you send this to the CVB and they agree, they're going to send it and the bench warrant, not signed yet, to the judge for him to, they're going to give him all the papers. Now, let's look at Rule 58 real quick, because this is the thing that allows all this to happen. And this is in the Federal Rules of Criminal Procedure. In general, these rules apply in petty offenses and other misdemeanor cases, and on appeal to district judge in case tried by magistrate judge unless this rule provides otherwise. So here's the pretrial procedures. Charging document. The trial of a misdemeanor may proceed on indictment, information, or complaint. Period. The trial of a misdemeanor may proceed on an indictment, information, or complaint. The trial of a petty offense may also proceed on citation or violation notice. Okay, so a petty offense is on citation, violation notice, but anything else is done by complaint, indictment, or information. Initial appearance. At the defendant's initial appearance on the petty offense or other misdemeanor charge, the magistrate judge must inform the defendant of the following. And it gives a list of all the things they have to do. And again, this is in Rule 58. And so, okay, this says that you can use a complaint in this pretrial procedure. And the complaint is the same as for probable cause. statement of probable cause. And you're going to send that to the CVB and see if they do something with it. Well, at least that's what I'm going to do. Summons and warrant. Upon indictment or upon showing by one of the other charging documents, right, that would be called a complaint, of probable cause to believe that an offense has been committed and the defendant has committed it, the court may issue an arrest warrant, or if no warrant is requested by an attorney for the government, a summons. The showing of probable cause must be made under oath or under penalty of perjury, but the affiant need not appear before the court. If the defendant fails to appear before the court in response to a summons, the court may summarily issue a warrant for the defendant's arrest. Very good. Okay. Okay, so that you can see that there are federal misdemeanors, because as I was reading this, like, well, what are the federal misdemeanors? Well, hey, somebody made a list of them. And if you Google federal misdemeanors, you could probably find this also. I mean, it was like in the first couple of hits when I Googled federal misdemeanors. And it's 19 pages of federal misdemeanors for all sorts of things, like embezzlement and theft. And because there's something wrong with the way this thing loads, I just copied this one by itself. But here, public money, property or records, accounting generally for public money, banker receiving unauthorized deposit of public money, court officers generally. Well, I would say that's what's happening in the courtroom. Because attorneys are officers of the court, and they're involved in a misdemeanor, right? And so, it's embezzlement and theft. Hey, it's a misdemeanor. They can be tried for it. They can be tried for all sorts of things. They have ones for securities. They have all sorts of different, as you can imagine, misdemeanors. And it's just a matter of, I don't know that we even need to pick them, but I'm saying if who's going to, we're given a sworn statement. Someone else is going to determine what the charge is. We may offer a couple of examples, but at the end of the day, that's what the U.S. attorney is supposed to do. He's supposed to charge them. We're just supposed to provide them with a sworn statement. And I've been trying for a long time to put a complaint into the right office, so this is just to me, oh, I didn't know this one existed. Here's another way to do it. If you do it under the petty offense misdemeanor, Rule 58, it can go to a magistrate judge to make the initial determination. And what they're going to do to start with is summons the person to court. You put the complaint in, they're going to summons them. Or if they believe there's a crime committed, they may go arrest them. We need to see if they're going to do it yet, but we got to start with, okay, well, that's what they're supposed to do. Let's move from there. Here's another one. 18 U.S.C. 401, power of the court. A court of the United States shall have power to punish by fine or imprisonment or both at its discretion such contempt of its authority and none other as misbehavior of any person in its presence or so near thereto as to obstruct the administration of justice, misbehavior of any of its officers in their official transactions. That's every damn piece of paper they put their pen to, or should have put their pen to, and simulate a legal process or simulate a legal document by not signing it, or using a pseudonym, a fictitious name in place of their full proper name, which is the name that they were licensed to practice law under. Disobedience or resistance of its lawful writ, process, order, rule, decree, or command. I mean, this one thing itself is really all I need. I need the power of the court to point. I'm going to point out the misbehavior of the officers and let the court take over. So everyday people, crimes, most federal offenders are of the petty variety. This is from 1985, but just to give an example. What does espionage have in common with chopping down a Christmas tree from a national forest or cocaine trafficking while speeding through Yosemite National Park? All are violations of federal law. Most federal lawbreakers are not bank robbers or alien smugglers, but everyday people who got caught riding a motorcycle off-road with spark arrestor or without a spark arrestor, or who ran a stop sign while on a military base. While judges, magistrates, and lawyers wrangle in federal felons with federal felons in the nearly 3 dozen courtrooms housed in the massive U.S. District Courthouse on Spring Street. This is in Los Angeles now. The vast majority of crimes against the government are processed anonymously behind the door of a third-floor courthouse office. Not in a courtroom, in an office. The Los Angeles Courthouse has jurisdiction over Federal Central District of Florida, stretching roughly from San Luis Obispo to Orange County. Handles citations. The Central Violation Bureau, however, handles citations or tickets for so-called petty offenses committed on federal property, including in a much larger area, said Janice McDowell, the Bureau Supervisor. The National Forest Service and Park Service, Bureau of Land Management, Veterans Administration, all branches of the military, and 300 other federal agencies send their citations to Los Angeles from federal property in San Diego, desert, Sierra regions of California, plus all of Arizona and parts of Washington. Yeah, McDowell said the violators are cited in the same way as drivers are stopped for traffic offenses. And with traffic tickets, most violators opt to admit their guilt by mailing in the fine, called bail, within 7 days of receiving a ticket. The ticket is sent to the Central Violation Bureau, which notifies defendant of the court date. Now, this said that it was California, and I know now they're saying that it's in Texas. So I'm going to send mine to Texas. But it appears that in every courthouse, federal courthouse at least, there's somebody who's handling these items that come in from the Central Violation Bureau, and those are the magistrates that we're looking for. So if we could find them locally, well, we could just send it to them and not have to go through the Central Violation Board. But what the heck? Let me try it and see what happens. On non-traffic cases, the magistrate has also the option to issue an arrest warrant. Well, that's what I want to use them for. Okay, so despite these notable differences, alleged misdemeanors are often receive the same treatment as petty offenders. Misdemeanors committed on federal enclaves frequently enter the federal criminal system in the same manner as petty offenses. Well, that would be through the Central Violation Bureau then, because that's how they get put in. Through a violation notice. And we read, well, it doesn't have to be the form, it just needs to be, that's one way to do it with the Central Violation Bureau form, but another way is on a separate form as a probable cause statement. In fact, even alleged felons have received tickets and been placed in the petty offense system. So this is just an input. And then once it gets there, they decide how bad it is. So what they say is a petty offense is anything up to 6 months. Class A is anything up to a year, and a felon is anything more than a year. Although federal magistrates and federal district courts have concurrent jurisdiction over misdemeanors, a magistrate, now see, it didn't say a federal magistrate. Here it says, although federal magistrates and federal district courts have concurrent jurisdiction over misdemeanors, a magistrate can try the case only if the offender waives his right to trial by jury in front of the district court. So they're still going to have to come answer. Right? It's just like, hey, if you put this in, it sounds like they're going to send something to somebody and make them answer. Or they're going to say, well, there was no crime committed. But that's the two options. Title 18, U.S. Code 13, laws of states adopted for areas within federal jurisdiction. So if they don't have a federal law to cover what happened, they'll use a state law. And this is for all federal enclaves. And all federal enclaves would be places that have a U.S. flag flying outside the building. The only exception could be educational institutions, from what we read earlier. But I don't know. Now, Title 42, U.S. Code 1987, Prosecution of Violation of Certain Laws. United States Attorneys, Marshals, Deputy Marshals, United States Magistrate Judges appointed by the District Territorial Courts with power to arrest, imprison, or bail offenders. Well, that's what they can do with this at the Criminal or the Central Violation Board. And every other officer who is expressly empowered by the President are authorized and required at the expense of the United States to institute prosecutions against all persons violating any of the provisions of Section 1990 of this title, 5506 to 5516, 5518, 5532, the revised statutes. I did a video on that way back when. I got to go back and see what that was all about. But I know what part of it was, is the fact that we're not being allowed to be registered on the local assessment roll, on the land roll. They have us on the property roll, not the land roll. So the land is vacant, right? So you're really not living there. You haven't established your domicile. And they keep us from getting on the proper assessment roll to say you're either occupying the land or you're the owner of the land, or the land is vacant. Well, on that list, all the land is vacant now because they're not putting their names on it. But these people have a duty to initiate prosecution against all persons who have violated these provisions. So we should go and see what these are and, point them out to the magistrate judge through the Central Violation Board on a sworn statement, which can be used for probable cause. 42 U.S. Code 1989, the United States Magistrate Judge, appointment of persons to execute warrants. The district courts of the United States and the district courts of the territories from time to time shall increase the number of United States magistrate judges, so as to afford a speedy, convenient means for the arrest and examination of persons charged with crimes referred to in Section 1987 of this title. That would be this one here. And such magistrate judges are authorized and required to exercise all the powers and duties conferred on them herein with regard to such offenses, in like manner as they are authorized by law to exercise with regard to other offenses against the laws of the United States. So this is just a way of saying, hey, these people have jurisdiction in all the laws of the United States. Said magistrate judges are empowered within their respective counties. So these people are in counties. Said magistrate judges are empowered within their respective counties to appoint in writing under their hands one or more suitable persons from time to time who shall execute all such warrants or other process as the magistrate judge may issue in lawful performance of their duties. And the person so appointed shall have authority to summon and call to their aid the bystanders or posse comitatus of the proper county, or such portion of the land or naval forces of the United States or of the militia as may be necessary to the performance of the duties by which they are charged. And such warrant shall run and execute anywhere in the state or territory within which they were issued. Wow, these people can call in an aircraft carrier to come to their aid. Such portion of the land or naval force of the United States or of the militia as may be necessary to the performance of the duty for which they are charged, which is to go and serve that warrant. Very powerful stuff. And, yeah. Okay. Be right back again. And you might find this to be interesting reading. You might want to Google the trials and tribulations of petty offenses in the federal courts. Mary C. Warner. Only one rule of criminal procedure applies to the trial of alleged petty offenders in federal court. Only one rule of criminal procedure applies to the trial of alleged petty offenders in federal court. This rule established a baseline for the trial of petty offenders. However, the district courts implement that baseline in many diverse ways. Procedures vary dramatically, blah, 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 blah. But hey, there's only one way to do it. When Congress passed the Federal Magistrates Act in 1968, giving federal magistrates jurisdiction over the trial of petty offenses. The legislators were concerned with the constitutionality of trials by non-Article III judges, i.e. magistrates, but they did not discuss the procedures that would be adopted. The Federal Magistrate Act left the procedures undefined to be filled in by an advisory committee. In 1969, that advisory committee passed the initial set of rules created specifically for magistrate judges. In 1990, a later incarnation of these rules was incorporated into the Federal Rules of Criminal Procedure as Rule 58. Rule 58 was created specifically for magistrates and outlines abbreviated procedure for handling petty offenses. The rule writes flexibility into these procedures and invites the district courts to improvise, yada, yada, yada. In the petty offense system, serious charges are brought without the safeguards they merit. Both serious and less serious charges reach trial posture without a legal determination of which rights apply and which procedures must be observed. They treat them all the same. If you put them in, they treat them like they're petty offenses until they're decided later. Sorting out serious charges from petty charges and providing these charges with those charged with serious offenses with the appropriate procedures should occur earlier and more efficiently in the adjudicative process. But it doesn't. They just, they're going to treat them all the same until they get there and figure out how guilty they are. The information and record keeping of petty offenses is sparse at best. A procedure should be implemented to sort serious crimes from petty crimes, but they're not doing that right now. So the abbreviated rules governing petty offenses created much interpretive space for district courts. The district-by-district development of procedures has created an esoteric and chaotic patchwork that variously over and under protects the rights of defendants. While there need not be complete uniformity, the system needs a baseline. In theory, Rule 58 provides that baseline. And Rule 58 says a trial can start on a complaint. That is the pretrial. That's all there is. The complaint, and then it's trial. Starts with your initial appearance. Federal enclave jurisdiction. The appropriate treatment of petty offenders is obscured by the multiplicity of federal and state laws and federal regulations that apply to them. The criminal law that applies to an offense is the law of the locality in which the offense was committed. Thus, the criminal law of California applies to crimes committed in California, except those that take place in federal enclaves within California. Well, how do you know it's a federal enclave in California? Right. It's flying a flag. If a crime is committed within a federal enclave, then federal law applies. There's your answer. It has to be federal. So what about the IRS? Well, they're sending you mail through the post office. Well, that's federal. Right? Anything that goes through the post office that was a crime is federal because, hey, it went through the post office. For example, the federal criminal law as codified contains few misdemeanors and no traffic offenses. So they're talking about adding these stopgap filling measure where they said, hey, we'll just use state laws in place of it. It does this by incorporating the criminal law of the state in which the federal property resides. That'd be like your penal code. In addition to the ACA, the federal agencies governing these enclaves have issued regulations incorporating non-criminal offenses such as traffic infractions. In some instances, the agencies have promulgated a nearly complete set of regulations to supplement and expand the otherwise applicable state criminal code. And those would be all those various federal misdemeanors that I showed on the list, right? They're coming from all these different sections of the code, but they're all considered misdemeanors. Well, that'd be a violation of the federal law, and that's what law enforcement's for. The rules governing offenses on federal lands are therefore a maze of competing and overlapping laws and regulations, and substantive changes to these laws are made to obscure are made in obscure federal regulations. As a result, defendants without lawyer and agency representatives without legal training attempt to parse out the confusion in order to ensure appropriate treatment of petty offenders. Petty offense is defined. A petty offense by operation of statute is an offense for which the potential punishment is no greater than 6 months in jail and a fine. The offense is serious if the defendant faces potential sentence longer than 6 months. The category of petty offenses are B, misdemeanors, offenses for which maximum penalty is less than 6 months. C, misdemeanors, offenses for which the maximum penalty is less than 30 days. And infractions, non-criminal offenses, for which maximum penalty is 5 days or less in jail. By contrast, a felony by operation of statute is a serious offense, punishable by a sentence longer than 1 year. Maximum penalty for an A misdemeanor is no more than 12 months in jail. An A misdemeanor is considered a serious offense, both in terms of alleged conduct and potential penalty. Although the definition petty excludes A misdemeanors committed on federal enclaves proceed through the same process as petty offenses unless or until someone sorts them out. They don't determine. You send it to them and they're going to determine after the fact. Right? But so I showed the one where 18 USC 402 or something like that, where it talked about things that an officer did in court. Right? That could be 30 days. Right? It could be a petty offense. It's good enough. Right? They broke the law. They'll have to stop. However, alleged A misdemeanors are entitled to greater rights than alleged petty offenders. Unlike accused petty offenders, but like accused felons, right? But like accused felons, alleged A misdemeanants have a right to counsel, the right to trial by jury, the right to prosecution by complaint or indictment. Well, we're going to give them a complaint, so hey, we took care of that part, and the right to be tried before a district court judge. So there you go. They're going to do it by complaint. They're going to summons the guy to court, and he can go ahead and get himself an attorney. And when they get there, they can, determine if they're going to let the magistrate handle it or if they want to go to trial before the district court judge. Although federal magistrates and federal district courts have concurrent jurisdiction over A misdemeanors, a magistrate can try these cases only if the offender waives his right to trial by jury in front of a district court judge. So you would have to go to court, right? When they get summons before the judge, they can have their say. Despite these notable differences, alleged A misdemeanors often receive the same treatment as petty offenders. The misdemeanors committed on federal enclaves frequently enter the federal criminal system in the same manner as petty offenses, though through a violation notice, or through a complaint. In fact, even alleged felons have received tickets and been placed in the petty offense system. And on the back of those forms, right, is a thing for the probable cause. And that will allow them to issue an arrest warrant. When the petty offense is committed on a federal enclave, a federal law enforcement officer issues a citation. One copy of the ticket is given to the offender. Another copy is sent to the Central Violation Board in Texas, CVB in Texas. The ticket does not specify that the recipient has been accused of a crime. That's really interesting. Doesn't say he's been accused. Someone else is going to make that determination. Right? It's just a sworn statement to the events. What was this? 30. So where was I reading that? Okay. The alleged felons have received tickets and been placed in the petty offense system. That was 30. Telephone interview with Monte Tingle, Clerk, Public Affairs Office, Central Violations Bureau in 2004. Out of 95 cases handled in the past year by the clinic, at least 3 have included a felony charge. What the form looks like. The CVB does not review or evaluate the contents of the citation. Okay, so in completing the violation notice, the law enforcement officer must check either mandatory appearance or optional appearance. If mandatory appearance is checked, the accused will be required to appear in court. The officer is supposed to consult the rules adopted by the local district court in order to determine which box to check. The CVB does not review or evaluate contents of the citations. So if you could find the people who have these frickin' books and get them to issue a citation to somebody for breaking a federal law, well, that would be one way to do it. But we don't have the book. So our choice is to use a complaint or an information. And they'll make the complaint. Information, indictment, or complaint. Forfeiture collateral, yada yada. That's about it for that thing right there. I wanted to go back though and see. I think it's in this one here. So again, the Central Violation Bureau rules for processing misdemeanors and other petty offenses are promulgated under Rule 58. Right, so you want to read Rule 58. The existence of local rules does not prevent law enforcement personnel from requesting the filing of a complaint against the defendant in lieu of issuing a violation notice. Okay, well, that's what I'm going to do. I'll file a complaint. So, complaint. The complaint is a written statement of the essential facts. Again, this is out of the Federal Rules of Criminal Procedure, Rule 3. The complaint is a written statement of the essential facts constituting the offense charged. Except as provided in Rule 4.1, it must be made under oath before a magistrate judge, if none is reasonably available, before a state or local judicial officer. Well, I say that's what you do when you fill out the sworn statement form. Arrest warrant or summons or on a complaint. If the complaint or one or more affidavits filed with the complaint establishes probable cause to believe that an offense has been committed and that the defendant committed it, the judge must issue an arrest warrant to an officer authorized to execute it. At the request of an attorney for the government, the judge must issue a summons instead of a warrant. Right? But if they don't request it, well, then they're going to issue a frickin' arrest warrant. And then the initial appearance. So that's the steps, right? Complaint, arrest warrant, and appearance. Appearance upon arrest. A person making an arrest within the United States must take the defendant without unnecessary delay before a magistrate judge or before a state or local judicial officer provides, unless statute provides otherwise. Pretrial procedure. Again, Rule 58. We've already looked at this, but I just want to go through it one more time. Pretrial procedure. Charging document. The trial of a misdemeanor may proceed on an indictment, an information, or complaint. The trial of a petty offense may also proceed on citation or violation notice. So whether we call it a complaint or an information, we're going to give a sworn statement of what we believe to have been a crime committed to somebody who's supposed to look at it and say, hey, it's probable cause this could have been a crime, and issue an arrest warrant or a summons to appear before court. And that's how an ex rel that would be like an ex rel prosecution. And so there'll be more of this to come. But before I leave, I want to find this one page of these federal misdemeanors. So give me just 1 second. Now, I won't claim to have any idea to know why it would be here, but under foreign relations / fraud and false statements, it lists under 18 USC, United States Code 1012, HUD transactions. Oh my, HUD's involved in everybody's mortgage. And they didn't lend you any money. And so, acknowledgement of appearance or oath. Wow, that would be like notaries that aren't really notaries that sign papers as notaries. False pretenses, compromise, gambling, Indians, liquor, malicious mischief, obscenity, obstruction of justice. Oh, obstruction of justice. Well, look at that. All of these are considered to be misdemeanors that you could kind of pick. And so if you watch the last video, when they said that Roe was guilty of or charged her with disorderly conduct, what they had done is taken the definition of disorderly conduct basically and put that down as the charge. And so if you were to go read these laws and say, yeah, that's what they did, and you just wrote the narrative of what it said into your frickin' sworn statement, well then put in parentheses 18 USC, whatever it is, and, you know, give them a clue which one you're headed to. But once they start investigating, that's the thing. Once they begin an investigation, well, anything in the military is investigatable. There is no such thing as entrapment. No. They will trap you any way they can, you and all your accomplices. And they don't care what you say. Your ass is going to jail. Postal service. Carriage of mail generally. I mean, got all sorts of things to pick from, and that's what I spend the next little bit doing is with Bobby in Arizona, we're trying to get either Fannie Mae, who's the trustee, who has a contract with a servicer and a document custodian, to give Bob his documents, the certificate that shows his beneficial interest. And, you know, they've run out of excuses and they're starting to stop answering the phone. So, well, this may be what we do next, is send them, see if we can send a love letter through the Central Violation Bureau. And, you know, I don't know who it is yet, but I'm going to find out who's in charge of Fannie Mae at the top, whoever the director is or chairman of the board or whatever. And him personally is the guy that we'll go after. Right? Because it's his ship that's committed the crime, so he's responsible. Okay, I'm going to leave it there, but I will ask just one more time, please, if you can, donate by PayPal, credit card, or mail. Just take a second now, stop the film, write that down, and take care of that for me. I could sure use it. Otherwise, I got to worry about it some more. I'm tired of worrying. Okay, take care, everybody. See ya.